Public hearing be called to order. Richard.
Frank Capelloni.
Here.
Charlie Coyle.
Here.
Bob Singer. Josephine DeLongo. Here. Suzanne Pine. Four present, have a quorum. County State Planning and Zoning Commission hereby gives notice of a certain public hearings to be held at 7 p.m. on Wednesday, January 2nd, 2008 at the East Haven Community Center, 91 Taylor Avenue, East Haven. Public hearing number 1. The petition of Robert P. Newbig to create a two-lot re-subdivision of 55.2 acres of land located at 110 Barberry Road, East Haven. Said public hearing was tabled from the December 5th, 2007 commission meeting.
Okay, the order of business will be the applicant will make his presentation. Anybody that wishes to speak either for or against will have the opportunity to speak. The applicant will make the closing statement, and then we will close the public hearing. Ready?
Hi, how are you? I'm Jim Laughlin, a lawyer with the firm of Laughlin Fitzgerald. David Giuliano is with me. Hold over the search here on behalf of the applicant, Mr. Newbig. Mr. Giuliano is with the engineering firm of Giuliano and Associates, also in Wallingford. This is, I propose, a straightforward re-subdivision application where we will be taking a 55-acre parcel and dividing it into two smaller parcels, one roughly 39.5 feet, the other 15.5 feet. Acres, thank you. There's no construction currently planned for the... There's no construction or any disturbance proposed for either lot right now. The more desirable, marketable lot is the 15-acre lot that's, as you're facing the property from Barberry Road, is to the right. As you're facing the property from Barberry Road, the property to the left is primarily all either wetlands or floodplain. And that's an important distinction. Right now, we will be adding only possibly one house to the area. Perhaps in the future, the 15-acre parcel will be subdivided, but right now, all we're adding is possibly one house, although there are no plans for construction of even that one house. So obviously, the bulk restrictions in your regulations have all been satisfied. Safety concerns for traffic I don't really feel are pertinent. There won't be any infrastructure burden added to the infrastructure as a result of this subdivision application. So we hope that tonight you will be able to act favorably on the application. Briefly, we also ask that you waive the open space requirement altogether. Primarily because if the 15-acre parcel is subdivided later on, that's when it would make more sense for you guys to ask for contribution of the land or a payment in lieu of the land. But right now, if you were to ask us for a contribution of open space or of a payment in lieu of that open space, you almost would be forcing the development of the entire farm altogether. Because if we were to give you a 10% cut of the property right now, and then the next guy that came in to subdivide the 15-acre parcel, if he were to also add another 10% contribution of the open space, that would compound the difficulty for the development of the land and might make it less desirable in the long run. This is historically a farm site, and we hope that it will develop in a staggered, controlled manner. You'll recall that a little bit further up on Barberry Road, a few years back, there was a subdivision that was put into place. And now the second stage is coming into play, and eventually that will be subdivided as well. Imagine if 4 or 5 years ago, the whole farm had been developed because of the 10% open space requirement. I don't know that back then we would have had the savvy or the knowledge to know what the market would bear, and it may not be as favorable as subdivision parcel as it is right Also, I would ask you to remember that that area that contains the floodplain and the wetlands is almost 40 acres. So the open space that is already out there makes it a very desirable area to live. It would make more sense that if you do want the open space contribution now, that it would be in the form of a payment in lieu of having to contribute the land. Because then you could take that money, put it into a bank account, and 5-10 years down the road, at that time, take that money together with other money contributed into the fund and buy property elsewhere in town that might have a better bang for the whole community, might provide a better open space in an area where it's more badly needed than out here. So, with that in mind, I guess questions so far as detail and well and subject should be directed to Mr. Giuliano, or if I can be any further information, I'm more than happy to do so.
Under this proposal, no development is proposed. All we are doing is taking a 55.2 acre parcel and drawing a line. I heard someone mention inland wetlands. Inland wetlands is for construction activity. Anytime you do any type of construction activity adjacent to or within the buffers of a wetland, you need a permit. All we are doing is cutting the line. Obviously, when anything is done on this property, we have to go probably more than likely to wetlands and then obviously back to the Planning and Zoning Commission. But if
Disagree.
I'm sorry?
I disagree with this.
Okay.
Statutes indicate quite clearly that before the Planning and Zoning Commission can act on a subdivision or re-subdivision application, if there are wetlands on the property, it has to go within the wetlands. I understand what you're saying. This is not your normal subdivision or re-subdivision application because you're just putting a line in. But I don't think, and I certainly will ask counsel, I don't think that eliminates your obligation from going to inland wetlands. When you get to inland wetlands and you want to advise them what you're doing, then I believe they can act accordingly and appropriately. But I don't believe that because there's no construction activity planned, that you automatically subvert or discount your obligation to go to inland wetlands.
I agree. Completely.
I just believe that's your obligation.
And the only other point is, with respect to the open space, by the time you put buffers on this, you pretty well incorporate a great deal of open space on this property. And I think it would be to the town's advantage to take the money in lieu of the land, because for anything to be done, you're going to get vast chunks of open space because of the buffers along the wetlands, but obviously
I thought the statute said that before you could go forward with any disturbance of a wetland, you needed to approach the Wetlands Commission.
The wetland statute here in section 7.2 says, an application for subdivision or re-subdivision of land, involving land containing wetlands or watercourses, we should submit an application for a permit to the agency no later than the day the application is filed with planning and zoning. So I was alerted to this issue. I've spent some time researching, talked to the members here, talked to inland wetlands, and I think we've taken the position that inland wetlands needs to be solved prior to planning and zoning making any determinations of whether or not it's going to be approved.
Can you hold on 1 second before acting? Just a second. We were caught a little bit off guard. Last month we were here, this was also referred out to various departments in the town hall, and we didn't get any feedback on this until just tonight. Is there any way, with our permission for an extension, we could continue this to next month so that I can check the statutes and touch base with council, and then if need be, I'll be withdrawing if that's the case, because it sounds like you're dead on that, but I just should double check.
I would request from you is tomorrow morning, either fax or send us a letter.
Sure. Or I can
Requesting
do it
a
on the end right now.
65-day extension, or if you
Or
want
do
to
it
do
on
it
the
now.
end. This isn't
Certainly,
my favorite stationery, but I'll have it before. I'll have it for you before I say goodbye.
Well, I think that's certainly within the purview of the commission, and if it's not done, we can't resolve in the wetlands, any other questions that we have, I